Morning. Are you Christian Kane?
Yes, ma'am.
Okay. We're going to lesser.
Yes, Your Honor.
This is cause number 24, DCCR 1947. I am going to take judicial notice of the court's file, including Mr. Kane was previously found not competent to stand trial, sent to the John Dunn Behavioral Science Center for Competency Restoration, received a packet from them dated September 15th of 2025. It includes the attending physician's report to the court from Dr. Labberis with the opinion that he is currently competent to stand trial. In addition, there's a trial competency evaluation report that was prepared by Dr. Robinson. Also has the opinion in that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
All right, then at this time, based on the two reports, I am going to find that Mr. Kane is competent to stand trial. Mr. Rojas, will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Kane, in cause number 24, DCCR 1947, the state's elected to proceed on the lesser included offense of a Class A misdemeanor evading detention, and that's from August 9th of 2024. And how do you plead to that charge?
Not guilty.
Okay, and are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, I did.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Mr. Kane, I'm going to find again that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor evading detention. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Are you Lucius LaFleur?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. LaFleur, in cause number 20-33730, I have a motion to revoke your community supervision. This shows that you were placed on probation November 3rd of 2021 for the third-degree felony offense of theft of material, and that was a 7-year term in prison that was probated for 10 years. Is that correct?
Sure.
And the
Whoa, let's pause here. These are serious probation violations. A Class A misdemeanor assault and possession of controlled substances. For viewers who aren't legal experts, this basically means he's admitted to breaking the law while already on probation, a red flag for the court. What would you do in his shoes? Think about the stakes here. His freedom is literally on the line.
And the motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of a Class A misdemeanor assault September 11th of 2023 in Angelina County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the offense of possession of a controlled substance January 23rd of 2024 in Angelina County, Texas. And is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department by mail or online for the months of April, May, June, July, August, September, October, November, and December of 2023 and January of 2024. And is that true or not true?
True.
Notice how carefully the judge walks through this. Every true plea is like signing a legal contract with your freedom at stake. Is why attorneys are keep leading true here means giving up the right to fight these counts later? It's dramatic, it's tense, and it's a pivotal moment for both legal strategy and emotional stakes.
You guys have an agreement, right? Do I need to keep going, Mr. Coleman?
That's what I was looking for. The state will waive the remaining counts.
All right, so stay will abandon 4 through 6. Mr. LaFleur, did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
True.
And did you plead true to those counts because they're actually true?
True.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
True. Yes, I did.
Thank you. And do you fully understand them?
Yes, I did.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. LaFleur is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the institutional division of the
And
Texas
here it
Department.
lands the probation, revocation, and the 2-year sentence. That's a big shift from hope for reform to hard time. Also, watch this. The firearm admonishment isn't just legal fluff. Texas law is strict. Owning a gun now could land him in even more trouble. It's a sobering reminder of how one set of decisions can ripple across your life.
Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm trying to print and it's just... I'm going to hand you the trial court certification that shows this was an agreement, so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because your probation you've been on it for a while, I'm not sure that you got this when you initially got on probation. But because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.